You've just been charged with a crime and now your attorney asks, do you want to take a plea deal or go to trial? One option feels safer. The other feels like a gamble. Everyone has an opinion. Your family, your friends, maybe even Google. But none of them are the ones facing the consequences if this goes wrong. I'm Nana Knight and I'm a criminal defense attorney here in California, and I've helped clients make this decision in cases ranging from misdemeanors to serious felonies. In this video, I'm going to walk you through how to actually think about this choice, what really matters, what risks most people underestimate, and how to decide in a way that protects your future. Because this isn't about pride, it's about strategy. First, what each option actually means. Let's simplify this. A plea deal means you agree to plead guilty or no contest, often to reduce charges or a lighter sentence, and the case ends. No jury, no witnesses, no trial. A trial, on the other hand, means that you plead not guilty and make the state prove their case beyond a reasonable doubt in front of a jury. And here is something very important. Most criminal cases never go to trial. So when you're deciding, you're not choosing between normal and extreme. You're choosing between certainty and risk. Now let's talk about what risk really looks like. The reality of going to trial. TV makes trials look dramatic and heroic. In reality, they are high stakes gambles. The potential upside, you could be found not guilty. You walk away without a conviction. You don't admit to something you didn't do. I've had clients go to trial and win. Completely cleared, future intact. When the evidence falls apart, it changes everything. The potential downside, if you lose at trial, the plea deal often disappears, and judges are not required to give you the same deal that was on the table before trial. That could mean harsher sentencing, more jail time, felony instead of a misdemeanor, no diversion options. Trials take time. Months, sometimes years. You live in limbo this entire time. I've also had clients who rejected reasonable plea offers thinking the case was weaker than it was. The jury didn't agree, and the sentence was worse than what they could have taken earlier. That's the risk people underestimate. Now let's talk about the other side, the reality of taking a plea deal. A plea deal is not weakness. It's risk management. The advantage is you control the outcome. You know the exact sentence. You avoid stress of trial. You often reduce the charge. Sometimes a felony becomes a misdemeanor. Sometimes jail becomes probation. Sometimes diversion means the case gets dismissed after completion. That certainty could be powerful. The trade-off. You accept a conviction. Even a misdemeanor can affect employment, housing, immigration, professional licenses. So this decision isn't about, can I win? It's about, what does this look like 5 years from now? And that brings us to the most important factor. How strong is the evidence? This is where strategy begins. Your lawyer should be evaluating witness credibility, physical evidence, surveillance footage, police procedure, constitutional violations. In California, the prosecution must prove their case beyond a reasonable doubt. But reasonable doubt doesn't mean perfect evidence. It means enough to convince a jury. If the evidence is shaky, conflicting witnesses, unreliable identification, weak forensic work, trial may make sense. If there's strong video, admissions, physical evidence tying you directly to the crime, that calculus changes. For example, if you're facing a DUI and the breath test is barely over the limit with procedural issues, that's different than a blood test that's double the limit with dash cam footage. Your decision should be based on evidence, not emotion. Now let's talk about something people forget to consider, the long-term consequences. Don't just ask what happens now. Ask what happens after this case is over. In California, convictions can impact immigration status, a professional license, firearm right, future sentencing exposure, or expungement eligibility. Sometimes a plea can be structured that avoids these immigration consequences. Sometimes a different charge protects your professional license. Sometimes trial is worth it to avoid a conviction altogether that's going to follow you forever, right? This is why your attorney strategy really matters, and it's really important that you go with someone who knows what they're doing and is highly experienced. Now, here's another question most people don't ask themselves. Do you have the resources to go to trial? Trials obviously take time, emotional stamina. They require financial resources. And this is a question you have to ask yourself. Are your witnesses willing to testify? Can you emotionally handle the stress of being cross-examined on the stand under oath? Can your job tolerate months of uncertainty? Sometimes the strongest plea deals appear right before trial. That does happen. This is when the prosecutor sees you're serious. Other times, early resolution saves you stress and money, and this isn't just legal, it's also very practical. But what about first-time offenders? California offers diversion programs in certain cases. Drug diversion, mental health diversion, deferred entry of judgment. These can allow charges to be dismissed after successful completion. The court orders you to comply with the terms that the court has ordered you to comply with, and you do that, you come back to court and your case is dismissed. But here's the catch. These options sometimes disappear if you choose to go to trial and if you lose at trial. So part of your decision is this a one-time mistake that I can resolve quietly? Or is this a case I need to fight publicly, because trials are public, right? So how do you actually decide? There's no universal answer. It really depends on your case. But here's the framework that I use with my client. How strong is the evidence? This requires a clinical analysis of what the evidence shows. Can the prosecution prove the case beyond a reasonable doubt? 2, what is the worst case sentence after trial? 3, what is the best possible plea outcome? Number 4 is, what are the long-term consequences? And what does the client want? What is the client's priorities? And 5, what level of risk are you willing to live with? Because if you choose to go to trial, that does not mean you're going to necessarily get acquitted, right? It depends on your case, the investigation that's been done in your case, and a lot of other factors that could be outside your control. Some clients cannot accept pleading guilty to something they didn't do. And I understand that, but others prioritize certainty and protecting their families from prolonged stress. And neither is wrong. The wrong move is deciding emotionally without understanding the stakes or listening to someone give you advice when it's not their case and you're just going with that person's opinion. But this is your life. This is a decision you have to make intelligently, voluntarily, with your attorney, properly evaluating the case and understanding the weaknesses and the strengths of your case, as well as the risk of taking your case to trial. So what is the final takeaway? A plea deal is certainty, right? It gives you a sense of control. A trial is risk. And sometimes risk leads to freedom. Sometimes it leads to harsher punishment. And your job isn't to be brave, it's to be strategic and very calculating. So ask these questions, demand evidence review, understand long-term consequences. What is the most important thing that matters to you with regard to the case, the charges that you're facing? Then make this your future, not just your pride. Now, if you're facing charges, the next thing you need to understand is how cases are built in the first place. Watch my video on 5 trick questions cops ask during DUI traffic stops, because what you say in those first 5 minutes can determine whether you're ever facing this plea deal versus trial decision at all. Click here and watch what's next, and I'll see you there.